Get
It
started.
starts out with Joan doing the predominant purpose stuff,
Yeah.
and then
So I can do this one if you.
Oh, that's
okay.
great.
yeah.
Yeah. So I'm just
You
highlighting.
found
I'll do
it.
this. Yeah. No. So I think, hold on.
Is Joan right? She's awesome.
No problem.
The next panel, who are here to my left, will be dealing with an area that has received increasing attention over the last couple of years with respect to the privilege against self-incrimination. And we've titled it, "My Words Can Never Harm Me," and the question is, can they? The chairperson of our panel is the Honorable Madam Justice Lynda Templeton. I've known Justice Templeton for many years. She was an assistant Crown in Hamilton for several years after a career in teaching. For a time, she was in private practice with the firm of Martin & Martin, but then returned to the Crown Attorney's Office prior to her appointment. For the last number of years, she was presiding in Brampton and presided over a lengthy retail sales tax fraud trial with an entirely well-wired courtroom. And I don't mean that from the standpoint of substance abuse, but I mean from the standpoint of the availability of technology, and received many commendations for the way that she conducted it. And our panelists, Michael Lacy, many of you will have seen his name in print as he is one of the editors of the Weekly Criminal Bulletin. He has been practicing since 1997 with the firm of Kelly, Jennings, and Lacy, and he's argued matters, trials, appeals, all levels of court, and one of the younger members of the bar, but certainly developing quickly an excellent reputation. And similarly situated is Joan Barrett of the Crown Law Office, Ministry of the Attorney General. Ken Campbell and I always enjoy, when we're putting together the panels, finding the opportunity for younger members of the bar to have the opportunity to take center stage. And Joan is a very creative and dynamic advocate, has come up with some very good ideas for parts of the presentation today, and we'll look forward to her participation as well.
Thank you, Jeff. Protection against self-incrimination is a fundamental precept in our justice system. Without this protection, conscription of evidence pointing toward guilt would know few, if any, boundaries. Closely allied with and often intertwined with the concept of protection against self-incrimination in discussions are the confessions rule, which is concerned with involuntary police questioning, and also the two other premises, namely the confessions rule, which I've indicated, and also the right to remain silent, which is enshrined in Section 7 of the Charter. As Mr. Alan Gold wrote in his paper recently entitled "The Right Against Self-Incrimination," and I'm going to confess to you now that my opening remarks are almost directly out of his paper, and I'm going to give him all due credit. There are two components to the privilege against self-incrimination, namely compulsory examination and incriminating effect. Within the context of a criminal trial, an accused person is not compellable. It is or her own choice whether or not to testify. Outside of the criminal trial, however, an accused person may well be compelled or required to provide disclosure, which often may well be self-incriminating evidence. Section 5 of the Canada Evidence Act and Sections 11C and Sections 13 of the Charter arise in consideration of these circumstances. As recognized by Mr. Gold in his paper, the privilege has been recognized to have the collateral effect of preventing any adverse inferences from an accused's failure to testify. So there are benefits flowing from this privilege which are not self-evident at the time of claiming the privilege. The Supreme Court of Canada, by a majority, reasoned that to allow adverse inferences to be drawn against an accused who does not testify at trial would be tantamount to conscripting the accused as a witness against himself. And that is, of course, the decision of the Supreme Court of Canada in R versus Noble. The privilege against self-incrimination also has been used to defend and explain the rule against this Crown splitting its case. And this rule has been applied strictly in R versus PMB, again a Supreme Court of Canada decision. Specifically, now, the rule against, or the privilege against self-incrimination has been addressed in a decision called R versus Noble. What does the word "used to incriminate" mean? What does that phrase mean? And can prior contradictory or inconsistent testimony be used by the prosecution to attack an accused's credibility without running afoul of the constitutional prohibition? In R versus Noel, which was a decision of the Supreme Court of Canada, cited at 2002 Supreme Court Judgments number 68, the accused was charged with first-degree murder along with his brother. He testified at his preliminary hearing and at his brother's trial. The Crown used this testimony for the purpose of cross-examining the accused at his own trial. Madame Leroux-Dubé, dissenting, held that, the court held with Madame Leroux-Dubé dissenting rather, the cross-examination had been aimed at incriminating the accused and not merely at testing his credibility. The court found that the Crown had been trying to incriminate the accused during cross-examination. Comments, Ms. Barrett?
Well, there's no doubt that, in my view, that the Noel decision drastically curtails the Crown's ability to cross-examine an accused on prior testimony given in another proceeding. And in my view, these new limitations on the permissible scope of cross-examination comes at the expense of the truth-seeking function of the criminal trial, which the Supreme Court of Canada has held in other cases is the ultimate aim of any criminal trial. But I think you just have to look at the result in Noel to know that the truth-seeking function is being compromised by the decision, because in Noel, in effect, the accused was granted a license to lie. When he's called as a Crown witness at his brother's trial, he admits participating in the murder. But by the time that his own trial rolls around, he's then singing a different tune and claims that he played no role in the commission of the murder. And the Supreme Court of Canada, it was Justice Arbour who wrote for the 8-member majority, held that the Crown should not have been permitted to cross-examine the accused on his prior testimony, as it was not admissible for any purpose, not even for the limited purpose of challenging his credibility. So the end result is that the jury will never know that this accused's testimony is totally inconsistent with what he told another court under oath, which one would think is relevant to any proper assessment of a witness's credibility. So at first blush, one might think, well, how does this stand with the Supreme Court's earlier decision in Caldup? Because it seems, one would think, to be inconsistent with Caldup. But the Supreme Court finds that Caldup is actually still good law. So the way that the court reconciles the two decisions is it reinterprets what Caldup actually stands for. And it says that Caldup only permits cross-examination on prior testimony that is either innocuous or exculpatory on its face. So having restricted Caldup in this fashion, the court then goes on and says that where the prior testimony is incriminating on its face, then its use in subsequent proceedings is going to be totally prohibited. So the Crown can't use it even to challenge and accuse credibility. But the problem, of course, that the court leaves us with and leaves trial judges to deal with is how do you distinguish then between testimony that's incriminating on its face versus testimony that's just innocuous or exculpatory. And Michael is going to assist us on that point.
And just generally in terms of Noel and the appropriate balance to the truth-seeking function, from the defense perspective, it struck the right balance. The criminal trial process always attempts to balance the truth-seeking function against the fundamental right that the accused shouldn't have to assist in the creation of evidence. And that's why the Crown can't subpoena the accused to testify at his own trial, even though the accused may be the best person to know what really happened at a particular event. And Noel is a welcome decision from the defense perspective because it does definitely curtail the ability to cross-examine. And effectively what the Supreme Court of Canada said was, there's no way that the jury would just use that for credibility purposes. If in Noel's case, he said he was involved in the murder on the one hand, and at his own trial said, no, I wasn't involved in the murder at all, I didn't kill this person, there's no way the jury could properly separate the one function from the other, the one use from the other. Of course, the most difficult question raised by Noel, though, is when is testimony given at a prior occasion innocuous as opposed to incriminatory? And in Noel, it was clear. Noel was an easy case because there were two different versions as to how the murder happened. So it was easy to say the prior testimony was necessarily incriminatory. But the question that is really left by the Noel decision, although the Supreme Court of Canada says you have to engage in this analysis between innocuous and incriminatory evidence, there's not a lot of assistance in that judgment about how you make that determination in close cases. And in the paper that's provided as part of the materials, I deal with that issue by commenting on the Noel decision. But there's reference to a recent Court of Appeal decision, which is of some assistance in that regard, the Kincaid decision. And the Kincaid decision is at 2003 OJ number 3480. It's referred to at page 7 of the paper, and there's a summary of the relevant facts in that case. And it's an important decision. Kincaid is an important decision for two reasons. First of all, it does give some insight into the innocuous versus incriminatory distinction, and it also gives some comments and some insight into the practical way in which these issues are going to arise at trial, and how do you determine in advance whether or not the Crown can cross-examine the accused. And in Kincaid, the defense sought an advance ruling from the judge and said, look, if my client were to testify, would the Crown be permitted to cross-examine him on the evidence that he gave in the co-accused trial? It was a separate trial. And in the course of that application, the defense didn't give the trial judge any disclosure of what Kincaid would testify to. So in fact, never said exactly what his testimony would be. And ultimately, the Court of Appeal upheld the trial judge and said the trial judge was correct in saying that the cross-examination would have been permitted because without knowing what the accused was going to testify to at his own trial, the evidence was in fact innocuous when he testified at the co-accused trial. And the facts of that case were he testified that he was at the location of the murder in and around the time of the murder, but hadn't participated in the murder at the co-accused trial. That was his evidence. And the Court of Appeal said, well, without knowing whether or not he was going to say something different at his own trial about whether he was there or not, on its face, that evidence is not incriminatory because it doesn't show that he was involved in the murder. And I think one of the interesting things about Kincaid when you look at it is the Crown conceded that if Kincaid were to have testified that he had not been in the home at all, then that innocuous, what appears to be innocuous evidence would have in fact been incriminating, and that cross-examination on the prior testimony would not have been permissible. And that's the area that, although Noel is very clear in terms of setting the parameters about incrimination and innocuous, it really does leave open this question that was picked up by the Court of Appeal, well, how do you decide? And I think that the best thing, or the only advice at this point that, or the only guidance we can give is that if the effect of the testimony at your own trial is going to be in somehow that what was innocuous is going to become incriminating, then that's prohibited as well. But the defense is going to be required to disclose that up front. You're going to be required to disclose what your client is going to testify to, either by summarizing it for the trial judge in a voir dire, which is obviously the preferable way to do it, or putting the accused on the stand in the voir dire. And of course, the danger is that if you provide a summary of what your client's going to testify to, the trial judge makes a ruling and then your client says something else. We sort of don't know where we're going to go in terms of the practical implications that are going to arise from that type of scenario. So that's sort of the area where I think counsel have to be alive. I think Joan will ultimately have some comments on whether Crown should even go down that road and try to cross-examine because of the concerns that will be raised on appeal.
As Michael indicates, I think the question is, what do we do with Noel, and what is permissible, what isn't permissible? In Michael's paper, he refers to a recent decision by the British Columbia Court of Appeal, and the site is on the slide. The decision is that of Henry, which just was released last month. Now, Henry is, the effect of the decision in Henry is it says that Noel will only apply in situations where the accused is compelled to testify as a Crown witness in another proceeding, and that the protection in Noel will not extend to situations where the accused testifies in his own trial, and then there's a retrial, and he gives a different version at the second trial. Now, from a Crown perspective, if this is a correct interpretation of Noel, then I think that that's great. But I have some serious doubts about the reasoning in Henry, and I say that for two reasons. First of all, if you read the Noel decision, there's a number of passages in Noel where Justice Arbour says that the Charter does not distinguish between testimony that's compelled and testimony that's given voluntarily. In addition, if you look at the facts in Caldup, Caldup is the exact same fact scenario as in Henry, where in Caldup, at the accused's first trial, he was charged with failing to stop under the criminal code. At his first trial, he says that he went to the police station and spoke to a particular officer. By the time that his second trial comes around, there's a new trial that's ordered, and at his second trial, by this time, he knows that the officer that he claimed to have spoken to was not on duty that day. So he then says, well, I must have been mistaken. It wasn't that officer. It must have been some other officer. And in Caldup, clearly the cross-examination is permitted. So if Noel is really just meant to apply to situations where the accused is compelled as a Crown witness, in my view, there would have been no basis or no reason for the Supreme Court to then go on and make this distinction between innocuous and exculpatory evidence versus incriminating evidence. There's just no reason for that. Clearly, the more obvious distinction is that in Caldup, the accused was testifying in his own defense, whereas in Noel, he was compelled as a Crown witness. There is a dissent in the Henry decision. As far as I'm aware, a notice of appeal has not been filed yet, but it will be interesting to see if a notice of appeal is filed. And in terms of practice issues for Crowns, I think if you're conducting a trial where you have a transcript of the accused's prior testimony, you have to ask yourself whether or not the prior testimony is incriminating on its face. But when you're making this assessment, bear in mind that if the trial judge wrongly permits you to cross-examine on testimony that ends up being incriminating, the remedy on appeal is going to be a new trial. So I think the better course, at least at this stage until we get some more guidance from appellate courts, is to not even go down that road because you're placing the conviction in serious jeopardy. And if you have a strong case, then why risk that? But as I said, I think that we will see more guidance from the appellate courts over the next few years on this issue. One final point is that I think if you're a Crown in a judge-alone trial, I think you can argue that you can cross-examine on any prior testimony, that you don't have to make this distinction, because clearly what's driving the Noel decision is the court's concern that the jury is going to use the prior testimony to incriminate the accused, that they will not follow their instructions, and that rather than limiting the use of the prior testimony to just an assessment of the accused's credibility, they'll actually use it. That was a mouthful. They'll actually use it to incriminate as evidence of guilt. And that concern clearly doesn't arise in a judge alone trial. So I think if it's judge alone, then you can argue that the traditional understanding of CALDIP is still the one that applies.
Just on that last point, I disagree with Joan's view of the restrictive interpretation of Noel. I think the Crown runs the same risk in a judge alone trial, that if you seek to cross-examine on this, especially given what drove the analysis in the Supreme Court of Canada, that we're talking about a Section 13 protection in connection with a Section 5.2 Canada Evidence Act protection as well. And I can see the Court of Appeal, in the same way that we don't allow similar fact evidence to simply, or all evidence to be admitted and let the judge sort it out properly at the end of the day, I can see the Court of Appeal having problems even in a judge alone trial. So I think the Crowns do run the same risk, notwithstanding Joan's view of the matter. I think it'd be an interesting case at the Court of Appeal to try and distinguish the principles emanating from Noel.
Before we leave Noel, I haven't discussed this with my counterparts here, but I want to draw your attention to a case, 2003 decision of the Alberta Court of Appeal called R versus Irvin. It's 2003 AJ number 732. In this case, the accused gave evidence at the preliminary hearing of his co-accused. The court used this testimony as evidence of lack of remorse in the sentencing hearing. The court held that in this section, Section 13 was not engaged. Prior testimony is only incriminating where the Crown's purpose in introducing it is to establish the accused's guilt for the offense charged. Section 13 has no application at a sentencing hearing. The Court of Appeal in Alberta, however, did review Noel and found that in this particular case, the sentencing judge had focused on the accused's conduct at the preliminary inquiry and not on his testimony. Section 13 is directed at prior testimony and not at prior conduct. So I draw that to your attention simply by virtue of the fact of a third case at the appellate level in this country where Noel has been considered, but in this case in the context of a sentencing hearing. On October 14th of this year, the Court of Appeal, just this week, released a decision in Ontario called Her Majesty the Queen versus Einar Bielbo, and I apologize to the appellant BJELLEBO. It was heard on October 6th and 7th, and as I've indicated, the decision was just released this week. In this case, Mr. Justice Sharp reviewed a decision of actually it was a jury case. It was 2 counts of fraud and 2 counts of uttering forged documents after a 9-month trial. The central issue on the conviction appeal was the admissibility of evidence obtained in violation of the appellant's Sections 7 and 8 rights under the Charter. After a lengthy pretrial charter motion, the trial judge found a violation of Sections 7 and 8, but ruled that the evidence should be admitted in any event under Section 24 sub 2. With respect to the Section 7 and 8 violations, the court found that the issue was one of timing, and in this case, it was Revenue Canada that was the investigating body. Revenue Canada's tax avoidance section began an investigation into the business losses claimed by various investors in partnerships in 1986. The Special Investigations section of Revenue Canada became involved in 1987. Warrants were obtained under the Income Tax Act and executed. The joint investigation shared information gathering and collaborated on strategy. The involvement of the Special Investigation Unit was not disclosed to the appellants, and active steps were taken to avoid disclosure of the Special Investigation Unit's participation until the execution of the Revenue Canada's search warrants. The trial judge ruled that in relation to this investigation, the point at which the appellant's charter rights arose was January 1988. By that date, there was reasonable and probable grounds to support a criminal prosecution, and the appellants accordingly were entitled to charter protection. The Court of Appeal has indicated in its decision this week that Justice Chapnick did not have the benefit of R versus Jarvis, 2002, 169 CCC 3rd, a Supreme Court of Canada decision, and R versus Ling, 2002 decision, 169 CCC 3rd. The appellants submitted to the Ontario Court of Appeal that the application of the predominant purpose test set out by these two decisions would push back the date of the violation that they were trying to establish. The Court of Appeal held as follows. As the Special Investigations mandate is prosecution rather than enforcement, the Special Investigation Unit's involvement is clearly an important factor to consider in determining when charter rights arise. The argument is not borne out by Jarvis, where at paragraph 88, the Supreme Court of Canada held that there is no clear formula that can determine when income tax authorities cross the Rubicon that divides compliance from prosecution and engages the adversarial relationship between taxpayer and the state so as to trigger charter rights. Mr. Lacy, what are they talking about?
Well, Jarvis and Ling is a very difficult decision, I think, from a defense perspective for a whole host of reasons. But effectively, what the Supreme Court of Canada says in Jarvis and Ling is there are situations in the regulatory context where, in that case, the tax context, it starts out as an audit. It's simply an audit, and investigators get involved, and they try and determine whether there's civil liability flowing from the failure to pay your taxes or some regulatory violation of the Income Tax Act. And during the course of that audit procedure, you're compelled as a taxpayer to cooperate with Revenue Canada. You have to speak to them. You have to produce documents. You have to have meetings with them. The powers are quite broad under the Income Tax Act, and they're set out in the decisions. And the issue arose that during the context of the audit, it may be that in providing that documentation, making those admissions, that it becomes clear that this is not just an administrative or regulatory violation, but that the taxpayer has committed a fraud. Tax evasion has purposely, not just tax avoidance, but purposely evaded taxes. And the line of cases before Jarvis and Ling dealt with that issue and said, well, there comes a point where what they're really doing is investigating a criminal offense, and you cannot use the powers under the Income Tax Act, the audit powers, to investigate criminal offenses, and there's use immunity to anything that you've provided to the auditors in terms of the subsequent criminal investigation. And the Supreme Court of Canada, in grappling with this issue, decided that ultimately you can have a parallel investigation. You can have auditors working, and you can have the Criminal Investigations Branch of the Revenue Canada Service working as well, seeing if there's any criminal violations. But ultimately, as long as it's an audit, the predominant purpose of the investigation is audit in nature, then whatever's provided by the taxpayer, be it documents or be it statements provided by the taxpayer during the course of that type of audit, where the predominant purpose is an audit, is admissible if subsequently the matter becomes a criminal. If the purpose changes at some point and it becomes a criminal investigation, everything that was gathered prior to that purpose changing is admissible against the taxpayer in the criminal matter. And Joan, I think, can help us out with sort of understanding, well, how do you determine what the predominant purpose of the investigation is, whether it's audit versus criminal?
Well, as Michael points out, distinguishing between audits and investigations is crucial because of the implications it's going to have on the ultimate use of the evidence or the information that's gathered. And in Jarvis and Ling, the Supreme Court of Canada held that where the predominant purpose of the inquiry is penal liability, then the government agency cannot rely on its regulatory powers to compel information, because it's at this stage that there is an adversarial relationship between the state and the individual has full charter protection. So once it passes this stage, then the officials have to get search warrants or obtain caution statements. So the question becomes, how do you determine what the predominant purpose of the inquiry is at the time that the individual is being asked these questions by the auditor, or is being asked to provide banking records, their financial records? And the Supreme Court held that there's 7 factors that courts have to look at. And the factors are set out in the slide. The first factor is, did the authorities have reasonable grounds to lay charges? So you have to consider the stage of the investigation. And it's interesting to note that prior to Jarvis, once there were reasonable and probable grounds to believe that an offense under the Income Tax Act had been committed, then the regulatory powers could no longer be used. And you had to rely on the search warrants to gather material. But under the predominant purpose test, this is no longer a determinative factor. You have to take a totality approach. So the second factor is whether the conduct of the authorities was consistent with the criminal investigation. So again, you have to ask, is this a focused, targeted investigation into specific conduct? Or is it more of a routine general inquiry by the auditor? Third, did the auditor transfer the file to the investigators? And again, prior to the Jarvis decision, this was viewed as a determinative factor, whereas now it's just one of many factors and is not going to be the defining turning point in the investigation. 4, was the auditor acting as an agent for the investigators? 5, did the investigators use the auditor as their agent to collect evidence? The 4th and 5th factors can really be viewed as sort of the smell test, because what the court's asking itself is, were the regulatory powers used to compel information for the main purpose of building a case for the prosecution? And if that's so, then the material gathered is not going to be admissible in the subsequent criminal prosecution. 6, was the material sought relevant to compliance or criminal liability? And then the 7th factor is the basket clause provision, whether there are any other factors to indicate that the audit had in reality become a criminal investigation. So again, what's clear is that under the predominant purpose test, there's no one single factor that's going to crystallize this adversarial relationship. The court has to take a totality approach, look at all of the factors. And Michael, I think you have some comments in terms of the implications of this decision.
I do, and they're set out in the slide presentation as well, which is also reproduced in your materials. So I won't go through them because time is tight. I won't go through them all. But one of the areas that I think deserves comment is the potential for abuse, because as a result of the Jarvis and Ling decisions, it is now in Revenue Canada's interest to prolong the audit as long as possible and gather as much information within the audit context as long as possible. And I can't say this has happened, but I can see them rewriting their policy manuals for their auditors on how quickly they should think that there's a criminal offense being committed and how they should make sure they exclude all possibilities. I mean, one of the things they talk about in Jarvis and Ling is you have to give Revenue Canada some flexibility. Even where there may be a criminal offense, there may be grounds to believe there's a criminal offense having been committed, they might still choose to deal with it by way of administrative sanction as opposed to penal sanction. And that's why they said the reasonable and probable ground test for charges is not the only factor. And the thing that strikes me about this case is this. A client comes into your office and tells you that he or she is the subject of an audit by Revenue Canada and is looking for some advice. You speak to the client. You find out that if the client is completely truthful with the auditors, it's going to be clear that they committed a fraud against the government, that they lied in filing their returns. Well, they have to cooperate with the audit. Your advice, you can't advise them not to cooperate with the audit, which is an offense under the Act. At the same time, you know that if they're truthful in the audit when they have this meeting with the investigators, they're going to incriminate themselves in respect of a criminal offense. And until they do that, in other words, it's not until they do that, that may change the predominant purpose of the investigation at that point, but the admission will be admissible against them. There's absolutely no doubt after Jarvis and Ling that the admission of criminal liability or criminal culpability will be admissible against them, and that's what happened to Mr. Jarvis. If you look at the facts of Jarvis, Jarvis was called in for a meeting. He goes in, he discloses the act that gave rise to the criminal culpability, and ultimately the Supreme Court of Canada said, well, up until that time, the predominant purpose was audit, and that can be used against him at his criminal trial. So as counsel, it's almost in your interest, if you know that's where it's going to end up, if your client is truthful, it's in your interest to try and persuade Revenue Canada that it's criminal. Because that way, that's the irony of the decision, and it's laughable, but it's true. Because if you can persuade them, I don't know how you do it, but maybe you need to write a letter and say that you're concerned that during this meeting your client's going to incriminate himself in respect of possible criminal offenses. Maybe you need to try and get assurances from Revenue Canada that they won't, notwithstanding that they can use it, that they won't use anything that he says for the purpose of criminal culpability. Maybe you need to go back to traditional voluntariness rules and try to make arguments that the statutory compulsion gives rise to voluntariness concerns, but that's been rejected. I mean, it was rejected in White in the context of accident investigation. So it creates a real conundrum, in my view of it, in terms of advising clients what to do, and it gives Revenue Canada huge powers, and the potential for abuse is obvious.
I think that there's also implications of the Jarvis decision on government agencies that use one staff person or one department to conduct both the audit function and the investigative function. Because applying the predominant purpose test is going to be a lot easier where you have separate departments. So I think that for agencies that use just one person or one department, there is going to be a need for those agencies to separate the functions and divide up those roles. And I think that that would serve the agency's interests in the long run, because I think what's going to happen is if you have one person conducting both functions, then courts will likely be more willing to find that this adversarial relationship crystallizes at a much earlier stage than if you have the functions being separated. And also, it poses, if you have only one person doing both functions, it also poses a problem for these parallel investigations, which Jarvis recognizes can be done. But how do you do it if it's just one person? Clearly it can't. So I think agencies should separate these functions.
Just on the way here, I was telling my law clerk that I'd been caught speeding some few weeks ago along the 401.
Allegedly speeding.
Allegedly speeding. Oh, I was speeding. I was so embarrassed when I was pulled over by the police, and I was so grateful I didn't have to say anything except hand over my license. And my position was not on there, and I had to say nothing other than to take the ticket and take my fine. If, however, I had had an accident, I understand under the Highway Traffic Act, specifically Section 199, I would have not only had to give him my license, I would have had to say who I am, what I was doing, where I was going, which is on my way to court in Chatham, and describe, much to my humiliation, why I was speeding and why the accident was created. Is that right, Mr. Lacy? And what are my protections, if any?
It's absolutely right after White, and White was probably known to most of you, arose out of a BC case and arose under that provincial statute, which compels any driver involved in an accident where there's a certain amount of damage to provide information to the police. And White has now been, I think it was clear that it applied in Ontario at the time it was decided, but now we see it in application in Ontario. There's reference to the DaCosta decision a decision of Madam Justice Wine. It's in the materials, where she finds that White applies. It's on all fours with the Ontario legislation. There's a recent ruling in a case that Justice McWatt did, it's not available online yet, where she followed DaCosta and said that it definitely does apply in the Ontario context. And we're sort of short on time, but to cut to the chase with White, what's going to be important, especially as counsel, is, and for Crowns to try and distinguish White, is the issue of whether or not the person actually factually was statutorily compelled, number one, but secondly, that the person had an honest and reasonable belief that they were required to cooperate and provide that information to the police. And White is instructive in that regard, as are the subsequent decisions, DaCosta particularly, in saying that that doesn't mean knowing the parameters of the statute. Justice Templeton would have known the statute because she's well-trained and understands the legal implications, but your average citizen who just has this general sense that when they're involved in an accident, when there's damage involved or someone's been hurt, and they have this sense that they're required to tell the police officer what happened, White has been extended in Ontario in lower court decisions to say, well, that's enough. That triggers the honest, reasonable belief that you were required to cooperate with the police. And it leads, if that's found to exist in light of the Ontario statute, it leads to automatic exclusion, essentially, under Section 24(1) of the Charter, of anything that you say in relation to that, unless the police officer delineate for you whether they're investigating only under the Highway Traffic Act or that they're also investigating possible criminal offenses. If they don't delineate it for you, the Crown, when you make that admission, and this is particularly applicable in dangerous driving cases or impaired driving cases, if you make the admission you were the driver, that's not admissible against you if you did it with that sense that you were required to do it because the law requires you to cooperate. And it's a very important decision. I think it's properly decided. At some levels, it's difficult to rationalize or to think about why the Supreme Court of Canada didn't adopt a similar analysis in Jarvis and Ling. But perhaps Joan's comments about, it's the same police officer investigating Highway Traffic Act or criminal code offenses, perhaps that gives some insight as to why White's a different type of situation than the Jarvis and Ling. And the only other comment I'd make about White is it's not confined to traffic accidents. Think about other provincial statutes where there's statutory compulsion. There's statutory compulsion under the Insurance Act to provide the details of loss by way of statutory declaration of proof of loss. The Syed case from the Court of Appeal dealt with that without deciding the issue. DaCosta deals with that as well, with statements made to an insurance adjuster where the accused felt he had to provide the insurance adjuster with the details. Madam Justice Wine excluded those statements as well. And there's a different context. One that is particularly one that I'm interested in, and I see Mr. Armenta, and he knows why, but is under the Coroner's Act in Ontario. Under the Coroner's Act, any sudden unexpected death in Ontario, the coroner is required to investigate. Under Section 16(1) of the Act, the police, the local municipal police, are required, they have a duty to investigate the circumstances giving rise to that death. And under Section 16(2) of the Act, anyone who has knowledge about the death is compelled to provide a statement about the circumstances of the death under penalty for failure to comply, which could include jail. So that's another context where White fits nicely, provided your client has some subjective understanding that they were required to provide those details.
Getting the high sign from Jeff, so our time's up.
Well, we'll now deal with some questions from other jurisdictions. And I might say, Justice Templeton, makes you feel any better. About 2 years ago, I was stopped for speeding, and I had my daughter in the back of the car, sitting in the back seat. And as I'm sitting there, as the cop is checking my license, my daughter sat there and shook her head solemnly. My dad, criminal lawyer, speeding ticket. I've never been so humiliated. So it can happen. Let's go in reverse order with respect to our ILN sites. We'll start with Windsor first.
Do you have any questions? No. No questions.
Thank you. Waterloo.
No questions?
Thunder Bay, I understand we have reestablished diplomatic communication lines.
You certainly have, and we have no questions.
Darn. Sudbury?
Yes.
Yes, I have a couple questions. Does the Noel decision help in one of our problems in charter applications has always been putting the accused affiant on the stand and being cross-examined. Can we use Noel to prevent the testimony in those charter applications from, which is, quote, incriminating based on the test against him in the subsequent trial? Michael, can you help us with that? Hello?
I think it raises an interesting question. I think Noel certainly helps to make the argument that because, and remember, you're compelled to provide that affidavit under the provincial rules in Ontario, so that you can certainly make the argument that having been compelled to do it and providing what may be incriminating information, I mean, certainly the Crown couldn't introduce the affidavit against your client at the trial proper. So I think using the same reasoning in Noel, if it's incriminating on its face, then the Crown can't use that at the trial either. They cannot cross-examine in that regard either. Now, I think the problem will be this innocuous versus incriminatory information. You may disclose something in the affidavit for the purpose of a charter application that is really innocuous when it comes to the issue of incrimination on the actual charge itself. And I think that's where you're going to have to, the delicate balance between those two issues. I don't know if Joan has any thoughts on that.
Well, I think if, with respect to the British Columbia Court of Appeals decision in Henry, I think if Henry is correct, then Crown should be able to cross-examine on the accused testimony in the voir dire, because again, it's the accused is voluntarily putting that evidence forward. But as I explained, I do have some concerns about the reasoning in Henry, and I tend to agree with Michael that I think that the ultimate test is going to be whether or not the evidence, if there's a risk of incrimination. If there is, then that's it. That's the test that rules whether it's given in a prior testimony, in a prior trial, in a co-accused trial, or in a voir dire.
We'll move along if I can. I know you might have had another question, Sudbury, but I would like to try in the time we've got to ask the other senators. Ottawa. I don't know if you can hear us. Ottawa, any questions?
No question.
Thank you. Niagara-on-the-Lake.
Apparently not.
Thank you. London.
No, thank you.
Kenora.
No question.
We were that interesting.
Losing our audience. Up to Kenora. No, I took that brief shaking of the head as no. Hamilton.
I'm not hearing it.
Yeah.
Oh, sorry. Did you have one, Kenora? No? All right. Hamilton?
Shaking my head.
Okay, good. Thank you. Burlington? We couldn't see on the screen, Hamilton. Thanks. Burlington next?
No, thank you from Burlington. No.
All right. And Barry?
I feel compelled to ask a question.
It's okay. We won't hold that against you.
I don't want this to be Thank you. It's on that, the most...
No? Okay. What's that? Sorry, couldn't hear it.
I always have this difficulty in that the court in that case said it didn't matter. We would have found that information out in any event through an independent source. So how do we deal with the situation where our client has given some information, and yet the authorities are going to turn around later on and say it didn't really matter, we would have found that out in other regards? Are there any pointers that you can give us in that issue?
Well, there is another case from our Court of Appeal. I didn't hear the first part of the question, but I think I've got the gist of it. A case called LZ that's reported in the CCCs. And it's a case where through cross-examination of a young offender at the adult's preliminary hearing, the Crown discovered some evidence that they otherwise didn't have. And what it was the young offender had made admissions to or confessed to someone else that the Crown didn't know about. And the Court of Appeal on appeal ultimately found, and then at the young offender's trial, the Crown introduced that person's evidence against the young offender. And the Court of Appeal looked at that issue of whether or not it would have been found in any event and found that it would not have been. And they excluded the evidence in ordering a new trial. If I got the gist of your question, that's the only thing I can think of in terms of case law that has dealt with the issue.
Perhaps then we'll come back to Toronto. And I know there's one that comes to my mind, so I'll exercise a bit of editorial license. And Noel talks about the potential requirement of a claim for protection under Section 5, Sub 2 of the Canada Evidence Act. Is that something that our panelists would recommend basically any time you call your client, regardless of whatever other considerations, almost to protect against an ineffective assistance of counsel claim? You instruct your client to always take 5, Sub 2 Canada Evidence Act protection. Comments?
Always, I think, is a difficult thing to say. The dynamics of a trial, recognizing that the jury won't be told what that means and that a trial judge shouldn't draw any adverse inference from that. And what the Supreme Court of Canada says about Section 5.2 is that the court has a gatekeeping function, that the court shouldn't allow someone simply to invoke it at large. They should make sure that it's being invoked properly. And this is a topic of discussion that could be a whole panel by itself, I think, in terms of looking at what they say about that. I'd recommend you read Noel carefully, though, about what they say about Section 5.2, and be alive to the fact that if your client invokes it in testifying in another proceeding, that they could be called upon by the court to explain why they're invoking it.
We can take, I think, maybe one more question, and then we'll have to move on to the next panel, but our panelists will hopefully stick around and respond to the Toronto people as well. One question back there.
George moved here originally from Sudbury. I'm proud of my hometown.
A great stand.
They ask questions. Okay, on the same thing you were just dealing with. Client has to testify at another person's trial. Okay? And you're going to claim all these protections and everything. Would it be a wise exercise of discretion to, first of all, sort of make a statement of, well, he doesn't want to testify and have the trial judge order him to testify?
And the question then for the ILN from the great history George Wooten has with Sudbury and encouraging them, individual has to testify at somebody else's trial. Would it be appropriate for him to, shall we say, object and seek the judge's requirement that he has to testify?
I don't know if you want to. I don't think you have to after Noel, because Noel says that the subpoena is not what triggers the protection, so that I don't think it's necessary. I don't know if Joan has any comments on it.
I agree with Michael. I mean, it doesn't matter whether or not the person has been subpoenaed, compelled by the trial judge, or just testifies voluntarily. It's not going to make a difference in terms of the subsequent use of that evidence. Again, everything goes back to this, to the test of whether or not it was incriminating on its face. If it is, or if there's even a risk of it being incriminating in the subsequent proceedings, then its use is totally prohibited, period.
Thank you. Any wrap-up comments, Justice Templeton?
Thank you very much for your rapt attention. And I get concerned when I see the title, Words Can Never Harm Me. This is words from the accused. Please don't take it personally in front of my court.
Thank you. We'll proceed on. Thank you very much. Next panel.
Wireless.
It's my pleasure to introduce the next panel to deal with issues surrounding the scope and consequences of arbitrary detention under Section 9 of the Charter. The moderator of the panel is Mr. Justice Harry LaForme of the Superior Court of Justice. After being called to the bar in 1979, Justice LaForme started his career with Osler, Hoskin, and Harcourt, practicing corporate commercial law, but soon left to become one of Canada's first Aboriginal rights lawyers, focusing his attentions on many treaty, land claim, and charter cases. In 1989, he was appointed as Commissioner of the Indian Commission of Ontario, and in 1991, the Chair of the Royal Commission on Aboriginal Land Claims. He was appointed to the Superior Court in 1994, and as I'm sure you're aware, has been involved in many high-profile criminal trials since that time. He's joined by David Tanovich, who's now professor with the Faculty of Law at the University of Windsor for, I guess, 6 or 7 years. Prior to that, David was one of the lawyers at Pinkowski Lockyer, who was a very regular customer in the Court of Appeal, arguing a very high volume of difficult appeals, all the while churning out books and articles. And we're grateful to have his very scholarly work on some of the issues surrounding the practice of racial profiling that you'll find in the materials. David Harris, the third member of the group, began his professional life as an assistant Crown Attorney in Toronto, but quickly switched to the defense bar, first with Carter, McCombs, and Minden, and then as a sole practitioner. David is one of a small handful of very formidable counsel whose practice consists largely of appeals to the Court of Appeal. And rounding out the group is James Stewart, who was called to the bar in 1977, and after spending time at the Ombudsman's Office and the Toronto Crown's Office, joined the Crown Law Office Criminal in 1985. He remained there until 1997, when he went to the Prosecutor's Office at the UN International Criminal Tribunals for Rwanda and the former Yugoslavia. He returned to the Crown Law Office in 2001 and became Chief Counsel to the Justice Prosecutions Group, which handles all the prosecutions of police officers and other justice officials. And James, as we may hear, argued the D. Brown appeal dealing with racial profiling. Justice LaForme?
Thank you very much, and thank you to the organizers for inviting me to participate in this. It's a real pleasure to do so, and especially on a panel with those people that tend to keep an eye on the trials that I do and the rulings that I make. This panel, ladies and gentlemen, is going to briefly examine what I think, anyways, is a thorny issue of racial profiling, or I think it's been referred to also as racial bias, in the context of police powers to arbitrarily stop and detain persons. For this discussion, a police sanction for this power is founded, at least in part, in judicial authority, such as R. versus Ladiseur. It's a 1990 Supreme Court of Canada decision, and that authority sanctioned random vehicle stops as being necessary to the enforcement of the Highway Traffic Act. Next case is R. versus Simpson, which is a 1993 Ontario Court of Appeal decision, where the court approved of police powers to randomly stop persons based upon articulable cause, or perhaps in clearer language, reasonable suspicion of criminal activity. That means, for the most part, as part of a criminal investigation. That's the foundation for this discussion, so let me first then turn it over to James Stewart, and the question is, what is racial profiling, and how is it relevant to Section 9 Charter considerations of arbitrary detention?
Thank you, Justice LaForme. I'd like to open my remarks by recommending to you Emil Carrington's paper entitled Racial Profiling, Black, White, Brown, and Beyond, for its examination of how the subject of racial profiling has been treated in the courts. And in the remarks I'm going to make, I'm glad to rely on Mr. Carrington's paper and the cases cited in it. The question that's been put to me is, what is racial profiling? And racial profiling can be described simply in this way. Racial profiling involves the targeting of individual members of a particular racialized group on the basis of the supposed criminal propensity of the entire group. The Court of Appeal for Ontario has accepted a definition of racial profiling in 2 cases, which are cited in Mr. Carrington's paper. The cases are Richards and Brown, and we'll be speaking about Brown, of course. And the definition that I've just given you is a more compendious way of expressing the detailed definition that you will find in those 2 cases as approved by the Court of Appeal. The phenomenon of racial profiling is is recognized to be both a conscious phenomenon and also an unconscious or subconscious phenomenon. And this point was made by Justice Trafford in his ruling in the Brown case. And he relied on observations made by Justice Doherty in the Parks case, which of course is the jury challenge case, to the effect that a segment of society operates on the basis of negative racial stereotypes. And therefore, Justice Trafford and subsequently the Court of Appeal for Ontario in Brown recognized that racial profiling can be a subconscious phenomenon. Now, if an agent of the state acts upon the basis of subconsciously held negative racial stereotypes, this could constitute racial profiling in the sense that we're speaking about it, just as much as if the agent acted on the basis of reasoning that was overtly racist. And looking at the matter this way is fair when one considers the impact of racial profiling upon the person targeted on the basis of negative racial stereotyping. The concern here is the impact of conscious or subconscious negative racial stereotyping, which casts the person who is the victim of it into the role of suspect simply because they belong to a particular group. Now, this is not to say that matters of race are irrelevant or always improper considerations. An obvious example would be a description put out of a person who committed a crime. And that description might involve a racial identification of the individual. And clearly it would be appropriate for the police to take that factor along with others into account in attempting to identify and apprehend the suspect. The issue is, unfortunately, I suppose, an emotionally charged one, but it requires a common sense, practical approach. It's difficult to speak about it in the abstract since so much depends upon the facts and context of the particular case. Now, the second part of the question that's been put to me is how does racial profiling become relevant to Charter Section 9? How is it relevant to Charter Section 9? Well, Charter Section 9 guarantees everyone the right not to be arbitrarily detained or imprisoned. Detention based on improper racial profiling would be arbitrary and therefore violative of the Section 9 guarantee. This proposition emerges from several cases, and I would refer you once again to Emil Carrington's paper, in which he examines the concern of the courts about this issue. I'm going to refer very briefly only to 3 Court of Appeal cases for the purposes of my remarks, and those 3 cases are Brown, another case with the name Brown, Brown and Durham Regional Police Force, and finally Simpson. I would suggest that the Court of Appeal decision in Brown is important because it accepts and recognizes that racial profiling can provide a basis for an argument that an arbitrary detention has occurred that violates the Section 9 guarantee and that opens the way to the granting of relief under Section 24 of the Charter. In Brown, Justice Morden described the issue at the trial of the respondent Brown in this way. There was only one issue raised at the ensuing trial. What was the reason for the officer stopping the respondent on the Don Valley Parkway? Was it because the respondent was speeding and had twice crossed out of and back into the lane in which he was traveling, as testified to by the officer? Or was it because he was a young black male driving an expensive car? The court then went on to say there is no dispute about what racial profiling means, and the court gave its approval to the definition that I've already referred to. And in paragraph 10 of the report, Justice Morden said, there is no dispute respecting the test to be applied under Section 9 of the Charter. The question is whether the police officer who stopped the motorist had articulable cause for the stop. Articulable cause exists where the grounds for stopping the motorist are reasonable and can be clearly expressed, citing a case called Wilson. If a police officer stops a person based on his or her color or any other discriminatory ground, the purpose is improper, citing Brown and Durham Regional Police Force, and clearly would not be an articulable cause. Accordingly, to succeed on the application before the trial judge, the respondent had to prove that it was more probable than not that there was no articulable cause for the stop, specifically on the evidence in this case that the real reason for the stop was the fact that he was black. So the Court of Appeal has defined the issue as a function of Section 9 succinctly in the Brown case, and that's a critically important case. I've referred to Brown and Durham Regional Police Force. That was simply a case that recognized that any discriminatory reason for exercising police powers of stop would be improper. That's the importance of the case. Simpson is an important case, too, because it deals with the notion of investigative detention. And there, the court, in approaching when the police had the right to detain someone for investigative purposes, spoke about reasonably based suspicion. And Justice Doherty put it this way at page 501 of the reported judgment. These cases require a constellation of objectively discernible facts which give the detaining officer reasonable cause to suspect that the detainee is criminally implicated in the activity under investigation. The requirement that the facts must meet an objectively discernible standard is recognized in connection with the arrest power. It serves to avoid indiscriminate and discriminatory exercises of the police power. I'm not going to read further from the judgment, but I recommend it to you. It's clearly important in terms of the definition of police powers, but it also signals the risk of a discriminatory use of those powers, and is therefore a case that bears on the issue that we're discussing. The issue, I would suggest, therefore, is whether the police can give a reasonable explanation for their actions in stopping someone that is supported by objectively ascertainable factors. In other words, given the particular facts set in the particular context, did the police act reasonably within the scope of their duties, or improperly on the basis of improper reasons, for example, racial profiling? The answer to that question will determine the outcome of an application for relief based on an alleged infringement of Section 9. Now, before I close, I want to alert you to another issue, simply alert you to it. It's not one that we have time to discuss today, but I want to bring it to your attention. There is a further issue to look out for. Here, we're examining the matter of investigative detention, and particularly the issue of how improper racial profiling might be an issue in relation to such a detention under Charter Section 9. The further issue, however, relates to Section 8 of the Charter and involves the extent to which the police, having stopped someone on a reasonable suspicion, or perhaps on a suspicion you wish to challenge as unreasonable, may search that person as a function of officer safety or other considerations. And the Manitoba Court of Appeal addressed the issue of search incidental to investigative detention in the case of R against Mann, which is spelled M-A-N-N, 2002, 169, Canadian Criminal Cases, 3rd Series, page 272. And the court found that the police did have the right to do a search incidental to investigative detention to determine whether or not the suspect was armed for reasons of public and officer safety. And the case, I understand, is now pending before the Supreme Court of Canada, so it's one to look out for, and it relates to the further Section 8 issue that may arise in these cases beyond the issue of Section 9. I'm not going to deal with other cases that are beginning to come out of the Court of Appeal, not just here, but in other provinces, for example, New Brunswick, where the issue of articulable cause, not necessarily related to questions of racial profiling, arises. But one can see that with respect to the jurisprudence that's evolving in relation to Section 9 of the Charter, one of the critical issues always seems to be articulable cause, whether or not the police acted on a reasonable basis, on the basis of objectively discernible factors, and not for improper reasons. I think that that addresses the issue of what is racial profiling and how it relates to Section 9. Thank you.
Thank you. That takes us into our second question, or Big Four.
Just want to add something. I mean, we're talking here today about racial profiling in the investigative context, but as you also heard, the real breeding ground for racial profiling is in the random stop context, the Latticeau context, where basically the police officer doesn't have to have any reason for stopping you over, for pulling you over. The officer can simply say, I was going to do a random license check. And because the officer doesn't have to have any basis to suspect that the driver doesn't have a license, it really is the place where racial profiling breeds. And so what I would urge you is that if you have a case where you have an African-Canadian client and the disclosure reveals that this was a random stop, the time has come to challenge Latticeau, and I think a good argument can be made that the Section 1 justification set out by Justice Corey is no longer valid in light of the evidence of racial profiling. And so if you ever have a random stop case, try and bring a constitutional motion, call some expert evidence on the evidence of racial profiling in this province, and it's time that Latticeau be struck down.
Thanks, Professor Tanovich. And you go into that in more detail in the materials I think they're in the materials anyways, the paper that Professor Tanovich has provided. Following our script, however, is how is race relevant to the concept of detention under Simpson authority of articulable cause?
All right, well, how is race relevant? Let me back up by talking a little bit about first principles. Under Section 9, there has to be a detention. In the Latticeau context, vehicle stop cases, there's a presumption of detention when the police pull your vehicle over. In the Simpson context, particularly in the context of street-level investigations, where the individual is walking down the street and the officer says, can you please come over? Can we speak to you? There has to be a detention in order for that encounter to be scrutinized under Section 9. Unfortunately, most courts have applied the Theron's right to counsel, Section 10, detention test in this context of investigative detentions. And I think it's unfortunate for a number of reasons. First, as a matter of interpretation, the courts have said that you have to interpret charter rights purposefully. And given the evidence of racial profiling, particularly in this city, it's important to ensure that there's some judicial accountability and oversight of the power of the police to stop citizens on the street. It's also important to ensure that people who have been victims of racial profiling have access to meaningful remedies. And they won't get access to Section 24, whether it be Section 24.1 or Section 24.2, unless they can rely on Section 9. So in order for these things to happen, I think it's important for the courts to define detention for the purposes of Section 9 in a meaningful and purposive fashion. And so that brings us to the relevance of race. How is it a relevant social context fact in the meaning of detention? Well, our courts have certainly recognized that police encounters are inherently coercive. Most people don't feel they have a choice but to comply with an officer's request. Well, those that have been victimized for the police, it's even more coercive, particularly for visible minorities. Given the history in this city, for example, of police-black relations, should it surprise anyone that a young black male will not feel free to refuse a police request to come over, to stop and ask a few questions. In fact, there's some evidence that in many families, parents teach their young children how to deal with the police to ensure that the situation doesn't turn violent. Children are taught, obey the police officer, don't do anything, don't leave the scene, don't do anything the police officer is going to consider suspicious that may escalate the situation into one of violence. So I think it's unrealistic to think that certainly in this city, any African Canadian would feel free to refuse a police request. And so it's relevant then to the issue of detention and psychological detention. And so I think there's a strong argument to be made that every police encounter involving an African Canadian, an Aboriginal Canadian, or other groups that are victimized by the police, that the encounter itself should be deemed a detention because it's so inherently coercive. And race plays an important contextual factor. That brings to the question, well, should this approach to detention, essentially a presumption of detention, just like there's a presumption of detention when the police pull over our vehicle, should this presumption of detention that I'm sort of advocating in the context of visible minorities, should it apply to everyone? And I think there's a good argument that every police encounter on the street should be deemed a detention for the purposes of Section 9. Simpson stops are different from encounters under Section 10, arrests and detention, where there's a right to counsel warning obligation on the police. Investigative detentions are intended to be brief. The police are simply to stop the individual, ask a few questions, confirm or deny their suspicions, and the individual is supposed to be on their way if the officer finds that there's no further basis to investigate. That's different from the arrest context, and that's different from the detention context where the individual comes to the police station and is questioned for many hours. Indeed, some courts have suggested that there may not even be a right to counsel obligation, warning obligation that is, on Simpson stops. And so courts are recognizing that there's a different kind of detention that's contemplated by Section 9 and Section 10. And so I think there's a good jurisprudential argument that there should be a presumption of detention, not only for groups that have been victimized by the police, where clearly every time the police stop them, there's a coercive element that's going to deprive them of their freedom to choose to leave. But given that it's supposed to be a brief stop, I think there's a good argument there should be a presumption for all street-level encounters.
Thank you. That being the case, David Harris, how does one go about building a case on racial profiling, for example, in the recent Brown decision?
Thank you, Justice LaForme. Well, the Brown decision, I want to give a very quick overview of it first before we get into the evidentiary building blocks for a racial profiling argument. Brown itself is superficially a garden variety over 80 case. A man was pulled over on the Don Valley Parkway, purportedly for speeding. He was a black man in an expensive, brand new SUV, wearing a jogging suit and a baseball cap. Of course, as we now know, he's a celebrity, a basketball player for the NBA Toronto Raptors, and that really sets the tone for the way the case then is argued in the trial court and in the appeal court. The judgment in Brown is not revolutionary in the way that the Parks judgment in the context of challenge for cause was. Nonetheless, it's incredibly important and of great use to us, I suggest. It really tells us what we already know, though, and that is that racial profiling is a fact of life, particularly in the urban centers in Canada. It was reassuring for all of us that the Court of Appeal did not shrink from that reality, that they accepted it and then commented upon it. Of course, you should realize that the ultimate issue in Brown was the issue of reasonable apprehension of bias. The argument, of course, was that Mr. Brown was stopped because he was black, not because he was speeding. It was an arbitrary detention Section 9 argument. The trial judge rejected that argument. and it seemed that he was greatly offended by it. The summary conviction appeal judge, Justice Trafford, and the Court of Appeal both held that the trial judge had exhibited a reasonable apprehension of bias in rejecting the racial profiling argument. In effect, he'd closed his mind to it and ordered a new trial. Ultimately, that was the critical issue in the case. Was there a reasonable apprehension of bias? But it tells us a great deal about racial profiling as well if we read the judgment carefully. There are three major things that come out of Brown, and they've been touched on already, so I'll run through them quickly. First of all, of course, it's explicitly recognized in Brown that racial profiling does exist. The court gives James Stewart here a pat on the back for making the concession that racial profiling exists. They call it a reasonable or responsible concession in the circumstances. And they obviously agree with it, and they cite social science research with respect to it. In the wake of the Brown decision, the outgoing head of the police union has said that police officers are immune from the ignoble practice of racial profiling. This, I suggest, we should view with great skepticism. To the contrary, it makes a great deal of sense that the stress and pressures of law enforcement would bring out racial selectivity as much as in any other field. And it was comforting that the Court of Appeal did not pussyfoot around the issue. They give us a solid foothold for further development of the racial profiling arguments. We can now cite Brown, and that can be our departure point. We don't have to get into the issue of whether racial profiling exists or not. It clearly does. It's been recognized by the highest court in the province. Secondly, Brown is important because it recognizes that racial profiling is not about only overtly racist views, but also about subconscious racial stereotyping. That's important, of course, because the overt form of racism is rarely found. By its nature, racial profiling is an underground and invisible species. There's a strong desire to hide it and not bring it up above ground. One would have thought this is obvious, but the trial judge in Brown seemed to think, in a number of comments he made, that it was only the conscious overt species of racism that was important. The Court of Appeal corrected that and made it very clear it's the subconscious species that really is the critical one. And the third thing from Brown that I'd like to point out is that it describes in a very helpful way to us some evidentiary markers of racial profiling. How do we know what racial profiling looks like? In the context of the Brown argument, James Stewart argued that the evidence at trial was incapable of constituting racial profiling. If correct, this argument would have short-circuited the bias issue because it wouldn't have mattered. If there was no live issue about racial profiling, then bias on the issue couldn't have amounted to anything. The court rejected this argument, and they put their stamp of approval on several evidentiary markers which characterize racial profiling. And the critical part of the judgment in this regard is at paragraphs 45 and 46. The court said, and I'll just read you the most important sentence from paragraph 45, where the evidence shows that the circumstances relating to a detention correspond to the phenomenon of racial profiling and provide a basis for the court to infer that the police officer is lying about why he or she singled out the accused person, the record is then capable of supporting a finding that the stop was based on racial profiling. So conforms to the phenomenon of racial profiling, first of all, and second of all, that there be some basis for finding that the police officer is at least prevaricating about why he singled the person out. The court then, in paragraph 46, goes through the circumstances in Brown, which I'll take you through briefly as well, and says, yes, these were capable of constituting evidence of racial profiling. How then do we build a racial profiling argument? And in the main, I want to consider the traffic stop situation. That's when, as well as the random stop, that's when the racial profiling issue will generally come to the fore. The problem we face from an evidentiary point of view is that it's so easy for the police to mask their true purpose. And the simplest example is provided by Brown itself, where the officer says, I pulled him over for speeding. The facade of a traffic stop stands in front of a potential improper purpose and obscures it, makes it very difficult to expose. The fact is, the officer himself, as Brown says, may not be aware of the element that bias has played in his stop. It's a deeply ingrained subconscious aspect. The jurisprudence is filled with the concern that a discretionary stop can in fact be on the basis of race. And Justice Sapinka's dissent in La Douceur is a cogent reminder of this. He said there that the roving stop can permit any individual officer to stop any vehicle at any time, at any place. The decision may be based on any whim. Individual officers will have different reasons. And he was far from comforted by the fact that this wide discretion existed. Our task is also made difficult by the fact that essentially what we're trying to show is a state of mind on the officer's part. We know from our work generally how difficult it is to prove state of mind. But yet, in the racial profiling context, that's what you have to do. So recognizing these problems, our aim is to attack and deconstruct the purpose attested to by the police for stopping and highlight the evidence supporting an improper purpose. I've divided the factors into 3 sets. And the first set of factors is, does the stop fit the phenomenon of racial profiling? That's the standard set by Brown. And of course, the fundamental misconception of racial profiling is that black men and women are more likely to be criminals. There's a connection there between race and criminal propensity. If we go beneath that, though, we see other startling presumptions. That is, from the Brown case, the fact that a black man is driving an expensive brand new car seems to bespeak a preference on the part of the police to believe that if you're black and you're wealthy, the means by which you have attained that wealth are probably misbegotten. In other words, probably criminal. So therefore, you're driving an expensive vehicle, you have expensive clothes, but you're black. There's something wrong with that. There's something out of sync with it. And most likely, you have a criminal past and are committing a criminal offense. Looking at it that way is one way to demonstrate how offensive a racial profiling syndrome is. Another aspect of it is that if you're out of place, you look out of place in the area in which you are, then that as well can be a key to the police that criminal activity is involved. The court in Brown accepted both these as factors which do suggest that there's a racial profiling process going on, that the police are racially profiling. The second set of factors is, does the highway traffic purpose appear flimsy or implausible? And the critical issue here is the strength of the case that there was actually a traffic violation, or the reason given for a random stop. If the traffic purpose seems nitpicky or overly technical or downright bogus, this is a evidentiary teaser which suggests a pretext purpose. Another aspect of this is what type of detail are the police on when they stop the driver? Are they on a traffic detail? If not, there may be a question. They say they've stopped for a traffic purpose, but they're out there to do other work. That doesn't make sense in the usual situation. And do they stop the car right away after the supposed traffic violation, or do they let the car drive on? Do they essentially conduct surveillance on the car? If that's the case, then it also tends to contradict that this was actually a traffic stop. In a similar vein, in the Brown case, the police look into the vehicle, according to Brown, and see who he is before they stop him. Now, why, if it's a true traffic stop for speeding, would there be a need to scrutinize the driver? That's another clue that there may be racial profiling at work. Lastly, was there a traffic ticket issued? If it's supposedly a traffic stop, then you would expect a traffic ticket would be issued finally. If it's not, then that may also indicate that it's a bogus reason. The third set of factors is, does the criminal purpose appear more plausible than a highway traffic purpose or a random stop purpose? You can and should subpoena police transmissions or computer checks that were made before pulling the car over. In Brown, it was clear that the police did a computer check on Mr. Brown's vehicle before they pulled him over. Why would they need to do that if it was truly a speeding stop? It was part of the suspicious behavior of the police in Brown. Further, do the police, once they pull the vehicle over, investigate the passengers? That doesn't make sense either in a true traffic stop. The nature of the questioning after the stop can be important. If the nature of the questioning is going well beyond traffic control sort of matters, then that can also be a clue that there's something else going on. Of course, all police prevarication in their notes and on the witness stand is helpful. In Brown, there was a second set of notes that the police officer had prepared. It looked like he was trying to cover up and attest to this being a traffic stop as opposed to a criminal investigatory stop. Any sort of conduct that appears that they're trying to paper over or cover up the real reason for the stop. The Peck case is a good example where you just don't have plausible behavior on behalf of the police. They say in the Peck case that they can see a bag of drugs from 30 yards off in darkness. So beware of the police claiming to have supernatural observational powers. Rarely true in my experience. So those are the factors, some factors you should look to building a circumstantial case of racial profiling. Of course, it's not an exhaustive list, but those are some of the ones emerging from Brown and from the papers that you have in your materials.
Thank you.
Can I make a comment?
Well, that's a...
You want to comment? Yeah.
James Stewart has a comment.
Just wanted to make one observation. I'm actually borrowing a comment made by David Tanovich in his paper. One thing that you have to prove is that the police officer has seen your client and therefore knows that your client is black. And in Brown, that was an issue. The officer said he didn't know that the driver was black till he got up beside the car. And Brown said the officer had drawn up beside his vehicle and looked in. So there was a real issue of credibility in that case. But what I want to underscore, and maybe David has actually covered this, but in his remarks, but you do have to prove as a fundamental that the officer knows that the person he or she is stopping is in fact black. Otherwise, you're not going to get even to first base. Some of the things that David has said, I know the Brown case obviously very well. The allegation about the second set of notes, there was an allegation. It was never established that there was a second set of notes. There were lots of issues of credibility that arose in the case, but I think David's outline of the factors is critical and important. And I think the importance of the Brown case is it tells you how to go about constructing the case. Whether in the individual case you're successful or not, it's very helpful to know how to go about constructing the case if your client is saying that he was unfairly targeted for reasons that had nothing to do with his driving of a motor vehicle.
Well, we can go on to the next question. I'm sure you may even have a comment on this one as well, and that is, Professor Tanovich, you argue for a shift to a Crown onus in Section 9 cases. Tell us why.
That's right. If I could just, though, before I do that, I just want to
no
couple of
doubt.
comments. Just first, Brown, to be clear, was an articulable cause case. It wasn't a random stop case. And that's why in the judgment the court talks about needing articulable cause. The officer said I was investigating the Brown for speeding. So it wasn't a random stop case. Second, on the point about the presumption of detention, right now there's not a presumption of detention for street-level stops, and so for a practical piece of advice, it's important that if you have an African-Canadian client, the client must testify and should testify. There's no good reason for the client not to testify, to talk about their experience and why they felt there was no choice but to comply with the police officer request. And there's a good recent case called Griffiths, where 11 criminal reports, 6 series, page 136, where the trial judge took that into account and found a detention. And I just want to briefly talk about this subconscious element that's talked about in Brown. It's not subconscious, not in the sense that the officer doesn't realize that he or she's using race to target the individual. That's not what's meant by subconscious. What's meant is that the officer actually thinks that he or she is doing so for a valid law enforcement purpose. It may be that the officer has been around Old City Hall for a number of months and sees what appears to be a disproportionate number of young African-Canadian males coming in drug court and thinks that there's a link between race and drug trafficking, and therefore goes out, and when they see something suspicious, that stereotype influences their decision-making process. But in reality, it's nothing more than stereotyping and nothing more than simply the product of prior profiling. Now, on this issue of remedies and the reverse onus, one of the things I've proposed is, and in my opinion, we're not simply at a stage in Brown as a recognition of racial profiling. In my view, I think the evidence goes much further than that and demonstrates that it's a serious, widespread problem amongst most urban police forces. And so given that social science evidence that's emerging now that demonstrates that it's a significant problem, my position is that every random vehicle stop of an African Canadian should be deemed an arbitrary detention under Section 9. And the onus should shift to the Crown to establish on a balance of probabilities that race did not play a role in the stop. And here's where I get the jurisprudential justification for that kind of an approach. There are a number of reverse onuses in our law. Under Section 8, there's a reverse onus. Where there's a warrantless search or seizure, the burden shifts to the Crown to establish that the search or seizure was reasonable. Under Section 24.2, there's a shifting burden for conscriptive evidence. The trial will not be rendered unfair where the Crown can establish there was an alternative means of discovering the conscriptive evidence. In substantive criminal law, there are reverse onuses. Insanity, automatism, the burdens on the accused to establish those mental disorders. And the justification given in those two contexts is the difficulty of disproving insanity, the difficulty of disproving automatism, and that the facts are within the peculiar knowledge of the accused in those cases. Well, those same kind of policy justifications apply in the context of racial profiling. As David has pointed out, it's very difficult to prove. And most of the resources are in the hands of the Crown and the police. An analogy to this sort of reverse onus is the challenge for cause process in criminal trials, where there now is a presumption after Parks that jurors are partial in cases involving African Canadians or Aboriginals. and that they have to be pre-screened. And so further support for this reverse onus can be found in the challenge for cause process. And there's another important reason that I advocate this reverse onus. And what I hope is that it's going to stimulate action, because right now there is no action. And the best way the Crown can disprove or satisfy their onus is if the police are forced to keep track of who they stop. And if the Crown can use that evidence, the Crown may be able to use that evidence to establish that there's not a problem. The problem of racial profiling is not as large or as widespread as I think it is. The Crown could also rely on that evidence to establish that within the particular police force, racial profiling is not a problem. Or for that particular police officer, it's not a problem. What I'm hoping is that this kind of reverse onus will stimulate action, and one important kind of action is to force the police to keep track of who they stop so that we can know the extent of the problem.
Thank you very much. I know we're out of time, but I think it would be patently unfair not to give James Stewart an opportunity to have a quick response to that.
Thank you. I recognize that in my work as a prosecutor, I'm responsible for a practice group that deals with the prosecution of police officers. So some of these issues, and I say it's rare, but it does arise, some of these issues are of real interest to me as a prosecutor, quite apart from the interest they may have for some of you as defense counsel looking at Section 9 applications. I suppose my response to David Tanovich's very imaginative argument with respect to reverse onus is to say that to recognize that arbitrary detention on the basis of racial profiling may be difficult to prove. It may be difficult to prove. That's true. But it's susceptible of proof. It's not impossible to prove. It is susceptible of proof, and in a proper case. And in my submission, the process is sufficient. I suppose in some ways I don't like the underlying assumption that every contact between a police officer and a member of a racialized group is necessarily, presumptively, improperly motivated. I don't like that assumption, and perhaps we could take that apart on another occasion. But how do you distinguish racial profiling cases from other instances of alleged arbitrary detention? Is it fair? You know, when would the assumption kick in? Is it the color of the skin or the color of the uniform? We live in a tremendously varied community. There are all sorts of different enmities and stereotypings that go on that involve groups other than simply whites and blacks. How do we determine when this reverse onus should apply? Or do we simply select particular groups and say it applies only in a case of police dealing with a member of that group? What real difference would it make to the inquiry? In the end, the Crown must still offer evidence of objectively ascertainable factors that provide a reasonable basis for detention. I don't think the analogies really stand up. If you recognize that a segment of society does hold either overt or subconscious racist views, it makes just perfect sense to allow a challenge for cause so that you avoid putting on a jury somebody who thinks that way. That's a different situation altogether. The warrantless search is different in my view too, because it's clearly established that you don't search without warrant, unless there are exigent circumstances or some other basis in law for doing so. The rule is that you have to get judicial pre-authorization. If you don't, therefore, the question does fall to the Crown to explain why not. It seems to me a completely different sort of situation. You know, when you're dealing with the issue of Section 24(2) and the unfairness or not of a trial, you're already dealing with a finding of charter violation. So that in my submission, the analogies don't really stand up. The statistical approach, which may be a helpful one that David is suggesting, doesn't exist now, and I don't know that one wants to stimulate that kind of work simply by reversing an onus under the Charter. So that, in my view, the process as it stands now, with all its difficulties, is fair and appropriate. And as I say, arbitrary detention on the basis of racial profiling is susceptible of proof. It's not impossible of proof. And just because it's difficult to prove doesn't mean that there should be a reverse onus. The onus should be the same as it is in relation to any charter application, in my view.
Thank you. And regrettably, we are out of time, and no doubt we could talk about this for a lot longer. But I think we have to
Yes, in fact.
turn
I
it over to
think-
questions?
Well, in fact, Justice LaForme will have our own equally pernicious assumption that having regard to the fact that the panel has gone a bit over time, we're going to presume any potential questions were answered and proceed on. And proceed on to our next session.
It's not often I get told I'm finished.
It's regular for me. Our next portion of the program is, I consider it certainly to be one of the highlights. We have, Ken and I, tried to invite different speakers for each of these sessions. And I don't know if we have ever specifically invited someone back for a second appearance. But on the other hand, when it comes to Professor Don Stewart, our next speaker, we are always prepared to make an exception. Professor Stewart, in addition, having been the editor of the criminal reports since 1982, is the author of Charter Justice in Canadian Criminal Law, published in 2001. There have been several recent decisions on Section 24, subsection 2 of the Charter, which are so significant that we thought to get someone who literally either can write the book, has written the book, or will write the book on the topic, we could do no better than Professor Don Stewart, and it is indeed a pleasure to welcome him here today.
Thanks very much, Jeff. I think this might be some people's worst nightmare at the end of a long morning, a professor sitting here with a 27-page paper. And I'm certainly not intending to present it at all. But I do want to try and stimulate you at the end of a long morning because I think this is probably the most important charter issue. After all, this is where the rubber hits the road. I mean, if we have lawyers arguing very hard and establishing a violation, it's all to naught if the evidence is not excluded. And the question of how and on what criterion the evidence is excluded is absolutely crucial. I'm reminded of an occasion when I went to a judges' conference in 1982 when one judge stood up and said, "I'm proud to say in the 5 years since the charter was proclaimed, I've not excluded a single piece of evidence." And whereupon a whole lot of judges applauded. "Good for you, way, yay." And I actually think that we're beyond that. I think that we have had a lot of experience of jurisprudence since that time. And let me get right to the meat of my paper. You'll see what the paper's about if you look at the table of contents on my tab 5. I regret that some of the index is a little out of kilter because they put it in a different format for these materials. But within a page or two, you'll find those beginning of those parts. Well, of course, you and I know that roughly speaking, Collins, Stillman, and all the rest of it seem to boil down to bright line treatment. It was, if it's conscripted evidence, it's gone. If it's non-conscripted evidence, it's in. That's what I mean by a bright light approach. I think that was true about 5 years ago. And in my little experience of prosecuting at Old City Hall, it was very hard. I was a prosecutor at the time. It was very hard even to entertain a reasonable argument on 24-2. Because once there's been a violation established, if it was hadn't been read his rights properly, the statement is going. If it was Section 8, but they had the evidence of the drugs, it was probably coming in. And I even found it hard to intervene, sort of to persuade some busy municipal judges to even listen to you on one side or the other. I'm here to say that, of course, the big signal important development in this area is the decision in Buhe. I think if you haven't read it, and I assume most of you haven't, in fact, have worked at it, if I could put it as strongly as I could, this is a unanimous judgment from the Supreme Court authored by Justice Arbour. The location is non-conscripted evidence. I would say that it's your obligation, if you haven't already, get hold of a copy of that judgment and read and reread it. It's obviously the advantage is it's 9-0. Even Justice Gontier was on the other side of most of these issues. Just before he retired, sort of said, "Okay, I concur with that." So, but what I think it's a very ambitious judgment by Justice Arbour, and it's full of insights into what she thinks the approach of her court should be. And it's 9-0, and it's unanimous. All right. In this paper of mine, I've given quite a lot of case summaries, and I'm certainly not going to go through them, including that of Buhe. The reason why it's hard to get into Section 24.2 jurisprudence is that they're all very long. And so the question is, what kind of precedent value does anything have, including Buhay? So Buhay, as you know, was a locker search case, and it happened in Winnipeg Bus Depot, and the Greyhound bus people smelt marijuana from a locker. They called the cops eventually went into the locker, found marijuana, and that was how the case developed. Did the police officers think of a warrant? One said, I didn't think of it. The other one said, actually quite reasonably given the status of the law, well, I didn't think we needed it for a locker. And if you think back in the school search case of MRM, Justice Corey left the issue of whether there's a privacy interest in public lockers in public spaces open. Well, now it's closed. The Supreme Court of Canada says there is a reasonable expectation of privacy in lockers. This case is very important for Section 8 generally. It's not my topic today. So Justice Arbour decides there was a violation, and not only that, and this is the big kicker for us, today's topic, the evidence should have and was properly excluded. All right, now what is can you, apart from reading every line of it and seeing exactly the nuances, what's the big principle that we're all supposed to work with here? And there are two principles. This is on page 4 of my paper, that she puts a lot of store on deference to trial judges. She believes strongly, I think if you've seen her writings before, it's not surprising. She believes that we should trust trial judges more. And so she says, by and large, courts of appeal should stay out of reversing decisions on 24.2. That's the one issue, and I'll talk about that just now. But the second one is the quotation. I'm sure most of you know about this, but the quotation that to me has the force of tremendous change is the quotation I give you at page 4, where she says, Section 24.2 is not an automatic exclusionary rule. Neither should it become an automatic inclusionary rule when the evidence is non-conscriptive and essential to the Crown's case. So no automatic inclusion when you're dealing with, they found the drugs, and the Crown standing up and saying, this is essential to our case, this is reliable evidence, we shouldn't exclude it. There's no automatic rule like that anymore. So a host, hundreds, literally, of Section 22 cases should not be applied anymore. This is the one, that line. All right, now, now, in my view, this will quite clearly lead to more exclusion. It should lead to more exclusion if properly applied. Now, it is true that if you defer to the trial judge's wisdom, you're going to have the trial judge, like the one I mentioned, who's never going to exclude. And so it cuts both ways. But the point is that if a trial judge says, this is a drugs case, or any case where it's a non-conscripted case, and the evidence is reliable, it's probative, this is a serious case, and it's essential to the Crown's case. As soon as he uses those words, essential to the Crown's case, and makes it sound like an automatic inclusion, that's a reversible error. But the biggest reason why I think there'll be more exclusion now is the reality that some time ago I wrote one article which I think was read only in the title, 8 plus 24.2 equals 0. And that was a summary of post-Stillman cases, mostly in the Court of Appeal. And most of the courts that I was reviewing seemed to be suggesting when there was drugs, since it was the real stuff, there's the white substance, it's going to come in. And I said that was sterilize Section 8. And I have a student following me, Nathan Gorham, who's about to be a fully fledged criminal law practitioner in this city. And he did a much more extensive survey and found that I was either wrong or things had changed. He summarized hundreds of cases and found that actually trial judges were beginning to exclude a lot in drug cases, not only just marijuana cases, but also cocaine cases. And so he came up with a title of 8 plus 24.2 equals 0.5. So if you put together the Buhay analysis, that it looks like trial judges, at least in the last 5 or 6 years, have been more likely to exclude than Court of Appeals on review, plus the other dictates of the judgment that it's no automatic inclusionary rule, I think the success rate should increase. Now, there's another thread of Buhay which is very important, As I've described it in my paper, I think to some extent this is a Sapinka fest. Justice Arwar goes back and picks up various little paragraphs and remarks from Justice Sapinka's vision of the Charter in 24.2, which is actually encouraging. This is all, we all have entitled to our opinions on this. It's encouraging to somebody like me who thinks if there's not a real risk of exclusion of evidence when there's a serious charter violation, it won't be much sense in having a charter anymore. So I think that's good news. If you're a Crown, probably bad news, because you thought that judges like Justice LaRue de Bay, Justice Gontier, and Bastarash were about to bury all that. Well, it's there. It's back again. 9-0, Justice Arwar. And the third principle out of Buhe is on, I think it's on page 5 of my paper, is a return to taking good faith more skeptically. She says, like as did Justice Sapinka, you can't just say this was an honest officer doing his job, he was trying to find the bad guys or trying to find the evidence. It has to be an honest and reasonable belief. Now, at this point in my paper, I turn away from Buhe and to draw your attention, and I want to do it in detail here, to lots of recent rulings, or several recent rulings, were taking good faith more seriously, particularly a case called Lau in the BC Court of Appeal and a case called Sheedle in the BC Court of Appeal. The facts are here at length, and the ruling, because they're very long cases. But the bottom line here is the BC police had decided when investigating grow operations not to knock. They'd take a battering ram, just go straight in. They developed this policy. And so their view was this is potentially dangerous to officers, and also we might lose the evidence. And if you read those two long cases very carefully, they say no. That cannot be good faith in terms of violating charter protection. Why? A couple of reasons, and you can see it all if it's of interest to you. Like, for example, it's a departure from the terms of the Controlled Drugs and Substances Act. So one of the panels says an illegal act cannot be good faith. A pretty strong statement, but that's what they said. The other Justice Essen said in Streetle, he says, it doesn't make any sense to have a blanket policy that it's all dangerous when you're investigating grow operations without any evidence that that particular operation has guns or something. And also the issue of destruction of evidence seems a bit far-fetched, he said. And so there's a strong statement of the importance of not quickly including because the officers say they were sincere. It's not a proper determination. Buhe and those cases. For those perhaps skeptic about the fact whether Buhe would result in more exclusion, I encourage you to read, I think it's at page 8, an Alberta Court of Appeal reported in two different names, Din, D-I-N-H, and Lam. It's another locker case, and we have Madam Justice Conrad eventually ending up in excluding the evidence with huge references to Buhe, and the clincher is the one I've mentioned. There's no automatic inclusionary rule for non-conscripted evidence. So there's a lot more to Buhe than I've mentioned, but I think that it's of sea change. All right. Now, I now move to about page 10. And this, to me, is a very emerging area and a very important one. If it's true, as it's always been actually, in non-conscripted cases, that we're now into Collins factors 2 and 3, how serious was the violation, and what's the effect on the reputation if we include or exclude? And often the latter, the last one, Collins factor 3, turns on how serious was the offense. So now we're balancing, it's not quite as simple as that, seriousness of the violation and seriousness of the offense. And I think that, to me, Buhe stands for the proposition, perhaps not expressly, that the seriousness of the violation is the key determinant, and it should be. Because if we have a situation in non-conscripted cases where judges are saying, well, there was a violation, it was quite serious, but boy, this is a serious offense. Maybe it's cocaine trafficking or something, so we'll let it in. Then it seems to me that we're going to end up with a very strange result that the charter does have no teeth when the offense is serious. So I think it's important that counsel, especially on the defense counsel's side, push, if they haven't already, try not to let the judge get to this is a serious offense, because sometimes it'll end at that point. And I don't think it should, and I read Buhe as encouraging the argument that the key determination is how serious was the violation. And I think that's the way it should be. Now, just on the issue of seriousness of the offence, I want to shorten it here at the end of the morning for you. There have been lots of recent pronouncements on marijuana. And the tendency of the cases, in the BC case of Sheedall, an extravagant remark from Justice Mary Southam, that it's first weapon of mass destruction, she's changed her view, it's not serious. In Ontario, we have the decision in the infrared photography case of Testling, where Justice Abella says marijuana is at the lower end of the hierarchy of harmful drugs. So at least in the marijuana area, there's plenty of precedent out there saying it's not all that serious. We've changed our attitude, I think. Not all consistent. There's a Campbell case I refer to you to be fair and objective, and in which they end up by not excluding the evidence. The Manitoba Court of Appeal describes marijuana as the pernicious scourge in our society. So there's no sense there. So, of course, we all differ as to what's serious and what's not serious. And as I say, and Canada's not unique about this. It's when we start excluding evidence, nothing to do with the truth of the matter. If we don't focus on the seriousness of the violation, we're going to end up by sterilizing the charter. Now, I have a few words, and I won't have an eye on the clock here. So moving to the section on conscripted evidence, page 13. Again, I think there's another shoe to come from the Supreme Court. I think they're positioning themselves to abandon any sense, and it's expressed in the first part of the quote that I read out, that Justice Arbor says it's not an automatic exclusion rule. I think they'll position themselves to go back to Stillman and say that we're not going to have an automatic exclusion rule for conscripted evidence. I think it's fair to say right now that more or less we still have an automatic exclusion right now, but I think there's signs that it's going to change. And I wouldn't be surprised when in the appropriate case we'll have another, perhaps a unanimous judgment saying exactly that. Now, there's more to this. There are some chinks for Section 10b violations. You'll know there's already an exception when the court's convinced that there was an irresistible desire to confess. That is not an automatic exclusion. But I draw your attention at page 15 to a recent pronouncement from the Ontario Court of Appeal. Actually, it's arbiter. It was a routine impaired breathalyzer case. They decide that there was actually no violation of 10b, no reasonable assertion of counsel with reasonable diligence. So it's absolutely all arbiter. And they end up by saying no charter violations, so the breathalyzer certificate shouldn't have been excluded. But then, in a rather extraordinary arbiter, Justice Weiler goes on and says, I've got it in the quotes there, the general rule that conscripting evidence obtained in violation of the accused 10b right should automatically be excluded because it impacts on trial fairness, has the advantage of predictability. This general rule may, however, provide a disproportionate remedy when the resulting charter violation is minimal. And so it's sort of like a plea, off the record in a way, not restive for the case, to the Supreme Court. She says the Supreme Court may be prepared to modify its approach. She picks out a few arbiters. Now, the point of mentioning this case, because from the point of view of people practicing in Toronto, there's an assumption in that case that there's still an automatic exclusion rule in Ontario for breathalyzer evidence obtained in violation of 10b, so that rule is still there. But clearly you have a court saying to the Supreme Court, please let us out of this. We want to start exercising some flexibility. Now, I just want to address, because to some extent I think academics are there to push. Justice Weiler says the trouble with an automatic exclusion rule is there's no proportionality. And she quotes one of my colleagues in Ottawa, David Pachaco. David Pachaco seems to have had a blind spot, in my view, in this area, because he keeps on saying that criminal trials should be about truth, guilt or innocent sense, and so therefore the Supreme Court got it wrong. In conscripted evidence should be excluded. I think it's very important to disavow ourselves from his analysis because, as I said, surely we know that the conception of a justice system that we have is not just about truth in the guilt sense. Sometimes we are letting people off, acquitting, because we believe that the enforcement of charter rights, whether it be racial profiling or anything like that, is important, and sometimes the price we pay is to try and improve standards of policing. And So I think the disproportionality goes back to my other argument is, if the Supreme Court of Canada were to say, we're not going to have an automatic exclusion for conscripted evidence, so it's all a matter of proportionality. You measure the violation against the seriousness of the offence. We're back to that problem. Does it mean that if we have serious offences, and there are lots of dicta out there, Justice Doherty is always doing this, in the end result of this balancing exercise, this was a very serious offence, the evidence was probative, we shouldn't exclude it. So I think it's very much important to the advancement of what I think is the proper balance to say, keep on saying, even if they start backing off the automatic exclusion of conscripted evidence, that in fact the seriousness of the violation is key. I'm going to just soft pedal very quickly the last part of the paper. And actually, from about page 16, I've actually just reproduced, with permission of the publishers, extracts from my book dealing with Charter Justice and Canadian criminal law on the difficult issue of what is conscription. I still believe that there's an open issue out there as to whether or not conscription just is limited to three categories of what Justice Corey called compelled evidence, statements, body samples, and use of the body. Many academics have a lot of trouble with how they mean compelled in these circumstances, but that's what he said. But he also has a broader definition out there saying anybody is forced to participate in the creation or discovery of evidence. So I think they're definitional issues. I actually think that when lecturers like myself start fussing about academic distinctions between conscripted and non-conscripted, I think a lot of practitioners and judges like bright-line distinctions. They like the view that, oh, well, whatever the court says, it's conscripted, out it goes, non-conscripted, in it goes. And I think the message here is that that's a bit easy, and I think we all have to work harder on the discretion, and I think they'll eventually break that down a bit. I have about two little points left. The one issue that absolutely flummoxes me is the doctrine of discoverability. That's page 18. So you know that under the category, it only comes up when we're dealing with conscripted evidence. And it was some sort of situation where they said, well, if the Crown can prove that they could have got the evidence in a lawful constitutional way, then in fact we can look at the second and third factors in Collins. And I find that, and I still do, and that's why I produced the whole part of my analysis in this, an absolutely perverse inquiry. You've got police officers who, by definition now at this stage, have violated, sometimes deliberately, a charter right. And you're asking the question, could they have done it without violating the charter right? Why? What's the point? And in my paper there, I refer you to an analysis by Carol Brewer from the Crown Law Office Criminal. And she said, it's not shouldn't be a boon to the Crown because there's a catch-22, which is, if they could have done it lawfully, then it contributes to the seriousness of the violation. So to me, the discoverability doctrine is a mess. But if you're, again, from the point of view of those like myself who think there should be a real risk of the use of the remedy of exclusion of evidence, I think you have to, as a defense counsel, not be beguiled by this discoverability ruse and have to keep on flogging away and saying, well, now we're into, because the Crown's established, Your Honour, that it's discoverable in a lawful constitutional means. Let me remind you that if they had those means, why didn't they do it? So it contributes to the seriousness of the violation, which is the key determinant. I have two last points, and I won't deliver them. I'll just note that where you can find them. At page 21, there's also a reference in Buhay by Justice Arbour to the ability to exclude at common law. It's sort of like the hurrah discretion, the hurrah, whatever it is, the panel before last was talking about. Nothing to do with 24.2. There's a sort of residual discretion for courts, apparently, to exclude if it ensure a fair trial. I tried my best when I did that book in 2001 to analyze the tests. I think it's very obscure. And the surprising thing is that they say there's always been this common law discretion in respect of evidence obtained by police misconduct. Well, there's never been such a discretion, so I don't know where they're getting it from. But anyhow, the point is that it's alive and well because it's asserted by Justice Arbour in this case. And I think what sparked her interest was the determination that, remember, it was a locker case which originally involved private security people. So she said, well, the charter won't apply to them. But I think what she's saying is, well, if it was based on their misconduct, maybe there'll be a remedy for defense counsel. I must say I find this a very unsatisfactory area of the law. My best shot at it, and it was originally contained in the book, is in those pages. The very last thing I want to mention is that I was asked to address the issue of procedural issues on 24-2 applications. Last page, page 25. And it's there for you to see. What's the latest word on can you raise a 24-2 a charter issue on appeal? There were various cases, courts that said, no, you can't. And then it sort of got honed down to being, well, you can't when the record at trial wasn't complete. And then we now have the controlling authority, which is Brown. So if the record is complete, in other words, all the facts necessary for a charter issue were found at the trial, then you can raise it on appeal. And in fact, Brown is a pretty dominating authority, has been distinguished and worked with. And the last thing is the recent decision of the Ontario Court of Appeal in Blum. In all provinces, we have notice that you have to give notices, you know more about this than I do, in proper form to the Crown of bringing a charter application. This was a completely routine case where the defense counsel said, I'm going to make a 10B application in the notice, and it turned out his argument was based on Section 7, and the trial judge just cut him off and said, we're not going to listen to that. Well, here you have a Court of Appeal saying that was wrong, and says that assuming that the real issue is whether there was prejudice to the other side, this case was a Crown, if there was no prejudice, there were other remedies anyhow other than cutting it off at the pass, and there could have been a brief adjournment. So in conclusion then, I just wrap it up again saying I think we're heading in the area of discretion for 24-2. I don't think there's been a more important case on 24-2 in the last, certainly since Stillman. It's a very key determination by Justice Arbour. It does just deal with non-conscripted evidence cases at the moment. I think it should be a push towards further exclusion in non-conscripted cases. Whatever happens in either area, I think that counsel, particularly, and judges should dwell much more on the seriousness of the violation than the seriousness of the offence. Thank you very much for staying around to listen to me.
Professor Stewart, I just have one request, if I could, just before you go. Because of the time, I think rather than entertain questions from the various sites, if you would be prepared to provide people here with your email address. It may be that people in various jurisdictions might want the opportunity to communicate directly with you for a question.
Free advice. Stuart D at post post.queensu.ca. Stuart D, S-T-U-A-R-T-D, at post.queensu.ca.
Thank you. Hopefully the mailbox won't be overloaded, but we will do that as an alternative to your remaining for questions at this stage. But thank you very much, Professor Stewart. Outstanding as always. I'll shift over to the middle.
What Jeff and I are going to try and do in the time that's left for us, and we'll try and keep it brief, is just to alert you to some of the recent charter cases in some of the other areas that haven't already been discussed by the others. The cases that we're going to mention briefly, at least, are included for the most part in the paper that's under tab 6 in your materials. The first one that I just want to briefly mention is the Papagiorgio case, which you can find at pages 1 and 2. It's the case that deals with the sensitive practical issue of the necessary form of disclosure to unrepresented accused in sexual assault cases. Basically what happens is the accused is represented initially, a videotape of a complainant's statement is provided to the defense. It's seen by the accused. He then discharges his lawyer, who then returns the tape to the Crown, and the then unrepresented accused wants his own copy of the tape. The Crown refuses to provide it, but offers an opportunity for him to view it in the Crown's office. He says that's not good enough. He's tried, he's convicted. The summary conviction appeal court judge actually stays the proceedings because of the failure to produce the tape as the accused wanted. Crown takes an appeal to the Court of Appeal, and the conviction is restored. And basically what the Court of Appeal says is that it was appropriate for the Crown in those circumstances to take that approach with respect to the issue of the form of the disclosure, relying heavily upon the Martin Committee's recommendations with respect to these kinds of cases and the sensitivity of the disclosure request. And the Martin Committee report says, as you may be aware, that where there's a reasonable basis for conclusion that providing materials with the unrepresented accused may jeopardize the safety or security or privacy interests, then it's up to the Crown to take reasonable measures to prevent those harms by providing private access under controlled conditions.
Perhaps we'll turn to the next area, and that's the issue as to ineffective assistance of counsel, as it affects our right to counsel argument, and as in turn it becomes an issue from the standpoint of the Court of Appeal. In this regard, there are a number of practical concerns as well as substantive concerns. From the standpoint of practical concerns, and I can advise that this is a component of Law Pro approval that's relevant here, one of the ideas that our insurer is concerned about are potential claims against us as criminal lawyers on the basis of ineffective assistance of counsel. If you have any reason to believe that you may be the subject of a claim, you're obliged by your insurance to notify Law Pro forthwith, and thereafter they'll provide you with counsel to assist you in representing your interests in the process that will then unfold on a potential argument at the Court of Appeal level. I have been in touch with Dan Pennington from Law Pro, and he's provided for me and for us a brief summary of issues that from the Law Pro standpoint are relevant. So it's not simply an insurance concern, it's a matter of your own professional reputation and as well how it could get translated into issues. And you'll see that with respect to the category, and this is just a two-page inclusion, he ranked them in diminishing order of frequency, the most frequent errors in criminal law claims. And he advised me that about 22% of their claims are under the category of failure to follow the client's instructions. I think something in the range of 15% was poor communication with the client and diminishing from their failure to know or apply the law, obtaining consent, and inadequate discovery or investigation of facts. Now, I might say that last one is an issue that has found itself as a way in which the Court of Appeal has had to consider it. It's not a standard that's considered to be one of absolute perfection, and anything shy of that could lead to a reversal. Rather, it's a high standard for counsel on appeal to try and show ineffective assistance of counsel, and can give you more of the legal principles in a moment. But really, you have to realize, of course, the three critical areas the client has to decide, plead guilty or not, the forum in which to be tried, judge alone, judge and jury, or try with or without a preliminary inquiry, and whether or not to testify. Major issues from the standpoint of ensuring that you wouldn't be the subject of that claim is to ensure that you have communicated adequately with your client and advised them of various options and issues so that they do understand the entire process. But you realize that, of course, it's your responsibility to make the decisions with respect to evidence that you will or won't call at trial. You want to try and manage the client's expectations. It's very important. And another critical one, and we as criminal lawyers are perhaps not quite as concerned on this, is the issue of maintaining notes and records within your own file as to the issues you have discussed with your client so that he or she is aware as to what it is that are the options that you have addressed and how you've determined they should be handled. You don't like to be faced with the situation subsequently of, I told my lawyer about these other three witnesses and they didn't interview them, when in fact they didn't tell you of that. Matters of that sort. A couple of brief highlights from the standpoint of legal issues for your concern, and Ken can give you the update, but he has summarized within his paper a number of cases, a couple of key ones, B parentheses GD at the Supreme Court of Canada, exhaustive with respect to issues on this matter. Joannice, coming back from 1995, the Ontario Court of Appeal decision. The case of P parentheses T was one in which a claim did succeed on ineffective assistance of counsel on the basis of failure to develop in cross-examination inconsistencies between the complainant's evidence at trial and that given in a videotaped statement and at a preliminary inquiry. So that did found a successful basis for the challenge. One that I have seen, and it's mentioned in Alan Gold's newsletter, a case called Wisconsin versus Zimmerman, 2003, W1-QL1233. decision of Wisconsin Court of Appeal where there was a failure to follow up on potential expert evidence with respect to cause of death. And it did lead to, in that case, a matter of a new trial on the basis of ineffective assistance to counsel. We might tend to forget about the need to be able to explore not only challenging prosecution experts, but exploring the potential for us finding experts of our own. And again, it's something to address. It's almost having to develop your own mental checklist of issues to think about in the context of defending a case, making decisions on what you will or won't do, documenting it, and being in a position to be able to say, I considered this, that, and the other, I explored this, that, and the other, and this is my response. And Ken can tell you about a couple of recent appellate decisions that deal with it further.
Well, the cases in the paper, the Jim and the Hayes case, one from British Columbia and one in Ontario, they don't say really that much new. They just give you more examples of how the principles are applied in practice. But as Jeff has mentioned, it is thankfully a rigorous standard that the Court of Appeal applies with respect to allegations of ineffective assistance of counsel, and they've described it as a high standard, one that's very difficult to successfully establish on appeal. The court always begins with a strong presumption that counsel's assistance to the accused fell within the broad range of reasonable professional assistance. It's not enough that judgment was imperfect or knowledge was imperfect or things weren't done exactly the way perhaps they ought to have been done with respect to a counsel of perfection. But really, it has to be so unreasonable, the conduct, that it fell below kind of the existing professional standard. And in applying that test, the court's made it clear as well that considerable deference and wide latitude are given to trial counsel in the way that they conduct trials and make decisions and form strategy, and that appeals are not to be forensic autopsies on counsel's performance. So given that fairly strong standard and given the complexity of the procedural protocol that the Court of Appeal has adopted, and you can find that on their website, these claims, while continuing to be made with some frequency, are not often successful.
Let's turn then, if we might, to the next issue that Ken has summarized in the paper, and it actually dovetails with what Professor Stewart talked about just towards the latter part of his comment. And the issue here is not specifically charter-based, although it probably has elements of it. At what stage do you get to the exclusion of evidence on the basis of conduct of the police that could be characterized as an abuse of process? And does it need to get to the level of being illegal police conduct? Could it simply be serious police misconduct in the obtaining of evidence? Can it lead to that evidence being ruled inadmissible? The case of McMillan stands for the proposition that apart from charter principles, on a common law issue for a remedy shy of a stay of proceedings, for an abuse of process, significant police misconduct to the point of illegality can lead to the evidence being ruled inadmissible. Ken, if you want to give everybody a brief summary of McMillan, and then we can discuss how it may or may not have changed the law.
Well, I guess what I think the lesson is for the police with respect to the McMillan case is that if they engage in conduct which can be described as criminal conduct during the course of an investigation in an effort to cause a witness to give evidence implicating an accused, even if they think that the evidence is going to be truthful, that they may very well be constitutionally deprived of the testimony of that witness on the theory that that conduct, that unlawful conduct, amounts to an abusive process which merits the remedy, while short of a stay of proceeding, merits the remedy of the exclusion of the testimony of that witness. And it arose in a case where the police arrested someone and confronted them with a statement that they had fabricated, that they prepared on an official-looking form that purported to be a statement of another individual that they created themselves, and had essentially created a forged document, as the Court of Appeal found, and they provided it to this individual, confronted them, and then, of course, he gave them the evidence that they thought they could get from him by provoking him in this way. And the Court of Appeal ended up concluding that this was unlawful conduct, that it was illegal conduct, it was an abusive process, and that the evidence ought to be excluded on the new trial.
Now, the area where that becomes, frankly, of personal interest to me, because it may amount to a change in the law from a decision I was trial counsel on. There's a reported case, Regina Ann Burek, which is B-U-R-I-C, reported at 106 CCC 3rd Series 97, 2-to-1 decision of our Court of Appeal. An appeal was dismissed by the Supreme Court of Canada in 1997. at 114 CCC 3rd, page 95. What happened in Burek was not as overt as the police forging a statement, but on the other hand, the police, prior to getting from the main Crown witness, a guy who was allegedly a participant in a killing, prior to getting his version, they showed him statements of other witnesses. They made no notes of what they showed him, and when it came to the voir dire lied, or at least did not acknowledge they had showed him these materials, but he indicated that they had been shown to him. The trial judge ruled in an application we brought under 24-2 and 7 that it would render the trial unfair to now let the Crown get to use this evidence. The method under which the police obtained it was so unfair, it was so improper that the remedy should be the evidence should be excluded. Majority of the Court of Appeals said no, it wasn't that bad. It really goes to witness tainting. We aren't really talking about police misconduct. It would be for the jury. They can untangle and sort it out. In a really good dissent, I say it was really good, Justice Laskin said, no, the focus is on serious acts of police misconduct. He didn't specifically call it criminal, but he identified a number of aspects of what the police did which was characterized as misconduct, which could properly found the basis for a judge ruling the evidence inadmissible. Well, we lost at the Supreme Court of Canada back in 1997, but it would now appear from the Court of Appeals review in McMillan, if you have police misconduct that's serious enough, and that's the way in which they got the evidence, maybe the evidence then goes out. Ken would say, I think, no, it's got to go to the point of criminal misconduct. I don't know that that's that clear, and I know that in another situation, if I had one of those again today, I think that Burek won't necessarily tie my hands and keep that evidence from staying out. What do you think?
Well, I don't often disagree with you, Jeff, but I think I have to here. I think that I think what's important about McMillan is the unlawfulness of the conduct, and the court kind of goes out of its way to make it clear that they find this to be a false document, that it's something that's facially prohibited by Section 366(1) of the code. In short, they found that the officer had engaged in the offense of forgery, and they called it abuse of process because they mentioned that whenever a police officer commits a criminal offense during the course of an investigation, that's always a serious matter, especially in cases where there's no kind of investigative necessity or exigent circumstances which might somehow justify this kind of conduct. And it was really in that context that they went to the appropriate route. I think it's a bit of a stretch to say that McMillan, without saying so, somehow overrules what the Supreme Court of Canada had said in Burek and Parzniak, but it's perhaps an argument that's open to being made.
Because Burek was not actually argued, although you might say maybe it didn't have to be, but Burek was not argued in the course of McMillan and wasn't referred to in the reasons. Next issue then, general category in terms of searches. Ken has a number of cases for us.
Actually, there's one case that I wanted to just draw to your attention that's not in the materials. It's a decision of the Court of Appeal in a case called Brooks that was just released by the court on September 29th of this year. It was a case where the accused it deals with anticipatory search warrants, and it's a case where the accused was convicted of a number of drug and weapons-related offenses. The police suspected that she was trafficking in crack cocaine and marijuana and obtained a general search warrant under Section 487.01 of the code, permitting them to do two things: to conduct surveillance with respect to her activities, and secondly, that if certain preconditions outlined in the warrant were met, that then they could go to her residence and conduct a search there. And the conditions basically were that in the 3 hours during which she was under surveillance prior to the entry of their home, was she seen in a motor vehicle giving drugs to people, and when she was arrested, were there drugs found in the vehicle? They were the kind of the preconditions in the warrant that would permit the search of her home. So it was very much an anticipatory search warrant. The police said that they adopted this investigative strategy because, according to them, news travels fast, and when someone's apt to be arrested for a drug offense, it's entirely likely that someone will go to a residence and destroy the drugs contained therein. The police conducted this surveillance. It seemed to meet the conditions. They then arrested her, and then they went with the warrant to her residence and found a fairly large quantity of crack cocaine and a small quantity of marijuana. Mr. Justice Moldaver, who gave the judgment of the Court of Appeal, concluded that indeed 487.01 allows for this kind of anticipatory search warrant. He said as well that there was much to be said about the legal requirement that's developed in the United States, and you can see the cases that he refers to in his judgment when you take a look at it, which require that the preconditions in these kinds of anticipatory search warrants be explicit, clear, and narrowly drawn. So there's some sort of a requirement to that effect, and the court went on to say that they were inclined to the view, without deciding it, that the preconditions in this case, as they were drawn, were acceptable. So it may be worthwhile going to that judgment to take a look at the terms there. If you have a case where a search warrant, an anticipatory search warrant, was executed, the court finally concluded that the search warrant itself, however, was invalid because it did not comply with 487.011C of the code, which states that a general warrant can only be issued where there's no other provision that could potentially justify the issuance of a warrant. And what the court eventually effectively said was that because there was no evidence of any real exigent circumstances beyond their feeling that something could happen generally to the evidence, that what the police ought to have done and simply got a more conventional warrant under Section 487 of the Code or under Section 11 of the Controlled Drugs and Substances Act. And the court held that the warrant was invalid, but eventually admitted the evidence under Section 24.2.
And it indicated that although they felt the violation was present, it was not considered to be that serious by proportionality consideration. On the other hand, the evidence that they did find was serious, significant, and was was strongly a key component of the case for the prosecution, so it wound up going in. Do take a look, just to follow up on a couple of small points to Professor Stewart's comments. The BC cases of Lau, and it's almost a companion case, although a different court, but in the same part of the CCCs of Shadell, where they used, as a matter of police policy, marijuana grow operations, used the battering ram to go in. The court felt that's a serious violation. And there we're into the realm of the manner in which the search is conducted. So that's an issue we don't see all that often in search cases, but that was really critical. They didn't get to use that universal manner of entering grow houses if they didn't have anything more than that, more than just a police policy. So those cases are both useful on that aspect of the search analysis, the manner in which it's carried out, and the basis the police offer for why they chose that particular method. Those are the comments on Lau and Shadell. Perhaps we can turn Richfield. Professor Stewart has really pretty much covered. Ken, you've included one, the duty of the police to hold off on questioning the accused, the case of NO, or NGO, Alberta Court of Appeal case.
It was a case that basically dealt with the police failing to hold off questioning someone, not so much to obtain evidence from them about their involvement in the offense, but simply to obtain other kinds of evidence. It's a voice identification case, and basically the accused is arrested, advised of his right to counsel. He asserts that he wants to speak to counsel, and then the police proceed to question him for about 30 minutes in the presence of this civilian expert that they'd retained, this voice identification expert, simply listening to his answers under the ruse that they're filling out some sort of administrative prisoner transportation form that really doesn't have anything to do with the offense. So he hears the accused speak and is then able to, as a result of hearing his voice, able to identify his voice from one of some key intercepted private communication. So it's a key piece of evidence. And what the Alberta Court of Appeal ended up holding was that this violated his right to counsel. In effect, the police compelled him to participate in a process that was intentionally designed to elicit evidence from him. That's what they did. Their obligation was to hold off gathering that kind of evidence until he had a reasonable opportunity to consult with counsel, and they excluded the evidence under Section 24.2.
And the last area that we'll cover in the time that's left deals with the issues regarding dangerous offenders versus long-term offenders. The Supreme Court of Canada dealt with this issue in a number of cases, and it has to do with the concept of being entitled to the benefit of a lesser punishment if there's been a change in the law at a period of time, let's characterize it, while your case is still before the courts. Ken, you've given us a great summary. If you can outline that for everybody today.
Well, it's the Johnson case that's the main judgment from the Supreme Court of Canada, pages 14 to 16. And I think significantly, the Supreme Court of Canada held that because of Section 11I of the Charter, the long-term offender provisions of the Code, that came into effect in August of '97 were potentially applicable in dangerous offender cases and proceedings that arose prior to that date. And the Supreme Court of Canada held that in outstanding cases, cases still present before the court, where the trial judge, in finding the accused to be a dangerous offender and sentencing them to an indeterminate sentence, failed to consider the potential application of the long-term offender provisions. Normally, what ought to result in those cases is a new sentencing hearing for the accused. So it seems to me that on a reading of Johnson, a whole lot of outstanding dangerous offender appeals just got a whole lot better.
On the other hand, if someone's had his dangerous offender hearing, has been found to be a dangerous offender, has appealed, has lost, is no longer in the system in the appellate level, could he claim the benefit of these decisions, say, well, just a minute, I'd like to get back in and get the opportunity for either consideration for a long-term offender or even a new hearing on the basis that my judge didn't consider it?
Well, I think if you're out of the system, you're out of the system. It kind of goes back to that. I mean, I think the closest example is the constructive murder provisions. When they were struck down, cases that were in the system got the benefit of those decisions. Appeals that were over, cases that had been concluded did not. And I think that's probably the bright line that the courts will draw between the cases now before the court with respect to dangerous offenders.
And with that, on that happy note of people going off to jail as dangerous offenders, and you might feel like you've been confined for an indeterminate period, I want to thank you all for attending. I want to thank Stephanie Spiers for helping us out substantially with the Law Society, but most notably, the real reason I keep coming back here, apart from a desire to learn, is to get to work with this guy. Ken Campbell is a pleasure to work with. We've had a lot of fun once again.
You too.
Thank you for attending. Don't forget the Law Pro credit format.